asking? So everyone, thank you for joining us tonight for our NPU University, Neighborhood Planning Unit Universities, Community Development 1003.003 Housing Security Series, Housing Resources for Tenants. This is one of 3 courses that we're offering as far as housing security that I am so happy that we're doing. And we're doing this course with Atlanta Legal Shield. As we log on, we have a couple of classroom rules. We ask that you all please keep your microphone muted. Also use the reactions to clap or give a thumbs up. And on the next screen, I will actually show you how to do that. If you have a question or you would like to make a comment during Q&A, please raise your hand to get in the queue. When I was discussing with our instructor, Ms. Margaret, we're going to allow for people to put questions in the chat. So in the event there's something that's on your mind and you don't want to forget it, we'll have it in the chat so we can actually go back and read those aloud. Or if you want to raise your hand, you can do that when we get to the Q&A portion of it. And please, please, please make sure all questions are relevant to the course content. We are the city of Atlanta, and we understand people have a lot of ideas and opinions, but this course is specifically about housing resources for tenants and pretty much rights and responsibilities for renters, okay? If you've been a part of NPU University, this is just pretty much some housekeeping rules on how to raise your hand. There is a reaction button at the bottom of your screen. You click on the reactions, and then it will allow for you to either clap, thumbs up, that weird smiley laughy thing, shock face, heart, or celebration, whatever you feel. But also you can raise your hand, and there's a select raise your hand option for anyone that wants to ask a question when we get to the Q&A portion. Our course instructor is Margaret Kinnear. Did I pronounce it right? Kinnear? Yes. With Atlanta Legal Aid, she's a senior attorney and tenant hotline director. And I'm going to actually turn it over to her so she can go ahead and get started. Margaret?
Thank you so much. If you'll just bear with me, y'all, for a second, I'm going to pull up my presentation.
And I apologize for saying Legal Shield because I literally, Atlanta Legal Aid is a really bad habit.
That's okay. Yes, but it is Atlanta Legal Aid. We do want to make sure people are going to do that right. So here we go. Okay. Well, thank you all so much for being here tonight, for taking time out of your Thursday evening to come and listen to me talk. I hope I'll be worthy of your time. As Samantha said, you know, we're gonna, there's gonna be a couple opportunities to answer questions as we're going and also at the end. But if you have questions as we're going, please feel free to put it in the chat. I do want to remind everybody this is being recorded and it is being live streamed. So please keep your questions general. If you have something that's going on with you, or you know someone who has something going on with them and you want to get into more specifics, please maybe ask a general question tonight and then follow up with Atlanta Legal Aid by contacting us next week so that you can talk to someone confidentially about what is going on with you and get more in-depth advice that way. Tonight, we're just going to talk about tenant rights and responsibilities. It's kind of an overview of what we're going to talk about. First, I'm just going to give you some real basic information, some background information, just some things to know. And then we'll talk about kind of the rights and responsibilities of the various parties. At that point, I'll stop and let y'all ask some questions about those topics before we get into the eviction process and basically what you need to know as you're moving out of a property. Okay, so the most important thing to know as a tenant in Georgia is that you always need to pay your rent in full and on time every month, no matter what is going on. Georgia law really doesn't allow tenants to withhold their rent. And so you want to make sure that you're doing that, even if there are issues going on with the landlord. And we'll get into a little bit more what to do if things get complicated. But for now, please know that it's really easy to evict someone for non-payment of rent, and that can have impacts on your credit and all kinds of other issues for folks. So please make sure that you are protecting yourself as best as possible by paying that rent. Never pay it in cash. You want to have some proof that you've paid it in case there is some discrepancy. Keep your receipts. And if the rent is refused or returned to you for some reason, make sure that you save the money order stub, whatever evidence that you have that you tried to pay that rent. You may need it if the case goes to court in an eviction posture. The other thing to know when you're dealing with a landlord or really any other business arrangement, put everything in writing, keep a copy of that writing. These days, that's fairly easy to do. An email is sufficient, especially when you're talking about things like putting a landlord on notice that something needs to be repaired. A text message is sufficient. Just make sure that it's clear when you're texting. Sometimes people kind of abbreviate things. Make sure it's clear. If you know you're having trouble getting a landlord to make repairs, make sure it's clear that you're letting them know that something needs to be repaired if you're texting, in case you need to show that to a judge later on. I know most people don't think like lawyers. Lawyers are constantly thinking of like, what if a judge has to see this? But an email or a text message is sufficient. I mean, obviously you can write a letter, or you can do whatever, just make sure it's in writing and that you have a copy of it somewhere. Because I usually get this question in these presentations, I will go ahead and address this now. Yes, Georgia is a one-party consent state in terms of recording conversations. So if you are a party to the conversation, you can record it. Meaning if you and your landlord are talking, you can record that conversation without necessarily telling the landlord. Now, you cannot record a conversation that's the landlord talking to the maintenance person because you're not a party to that conversation, but you can record a conversation that you're a party to. I will strongly advise you to remember you are being recorded too. A lot of times people get upset, understandably, but if you're going to record a conversation, please remember it's recording you too. Okay. There are a few different types of tenancies that you can have. These are all kind of lawful, well, except for the tenancy and severance, but we'll get that in a minute. The first is a leasehold. That just basically means you have a written lease and you're during the term of that lease, and it has all of the terms of the tenancy are written down. And the lease hasn't expired yet. A tenancy at will is just a tenancy where there's no specified end date. So this can happen if you had a lease when you moved in, and then that lease expired, but you continued to live there on a month-to-month basis. Most written leases will actually include a provision that talks about how that could happen. And the terms of the lease that you signed previously just continue on a month-to-month basis. So you still do have a tenancy, it just doesn't have a specific end date. The same is true if you move into a property and there never was a written lease. It was always a verbal agreement. Georgia does recognize that as a valid tenancy. Maybe something was written down like the rent amount, maybe nothing was ever written down. But you have a tenancy at will, also known as a month-to-month tenancy. And so at that point, or with a leasehold, proper notice has to be given to change the terms. If you had a lease, the lease may say what kind of notice has to be given. So if the landlord wants to change the rent and you're a month-to-month tenant, they can do that. The default rule in Georgia is they have to give you 60 days notice. If you had a written lease, the written lease may say something different. The written lease may say 30 days or something like that. So if you did have a written lease, make sure you go back and check that. The same is true if you want to end the tenancy. If you're in a tenancy at will then the landlord, the default rule is they have to give 60 days notice to end that. The tenant has to give 30 days notice. And again, please make sure you put that in writing and keep a copy so that you can show when it was that you gave notice that you were going to be leaving in case it becomes an issue later on. A tenancy at sufferance is just kind of a fancy way for saying that a tenant had a legal right to be in the property and doesn't anymore. So maybe the lease ended and the landlord gave notice saying, I don't want you to live here after your lease ends, and that was proper. When the lease is over, the tenant needs to move out, otherwise they're considered a tenant at sufferance. Basically what that means is that the landlord can go ahead and pursue an eviction. If the property is sold, the new owner will take it subject to the terms of the tenancy. So if Samantha sells her house to me and there's a tenant living in that house and they've got 6 months left on their lease, I'm just going to be their landlord for the 6 months of that lease. I've taken that property subject to that tenancy that's in place. Same is true if it's a tenant at will. If there's just somebody living there, they don't have a lease, but they've been living there for a while and they're paying rent. If I buy the property, they're my tenant, and I have to give proper notice if I want them to move out and all of that. They should, once they're on notice, once the tenant is on notice that there's a new owner, they should be paying rent to that new owner. And I understand sometimes it can get things can look a little shady. So if you're ever concerned about that, go ahead and, talk to someone, call legal aid, call someone to, kind of try to figure out what's going on. And make sure that you're trying to make sure you're paying the rent to the proper person. If the property is sold at foreclosure, the Protecting Tenants at Foreclosure Act, which is a federal law, will apply. And there are some folks that it doesn't cover, like the former homeowner or their family. But for the most part, if it's a bona fide tenant, someone not connected really to the former homeowner, just somebody who was renting, and they're living there and had nothing to do with this foreclosure, then they have the right to remain for the remainder of their lease. And the new owner has to give at least a 90-day notice to them before they can file an eviction, just to make sure that they know that they need to vacate and that their rights are protected. Quickly though, not all housing situations are landlord-tenant situations. So somebody who is living with their domestic partner, the domestic partner may be the homeowner, but that doesn't make the person who is in the relationship with that person a tenant. Family situations, generally not landlord-tenant. They could be, but generally they're not. Roommates, also not landlord-tenant to each other. A landlord may be able to evict the tenants, but the tenants can't evict each other. So just to kind of be aware of that. Okay, a few things to be aware of before moving in. When you go in to fill out an application, you're probably going to pay an application fee. It should be, I know they're starting to creep up like everything else, but this is should be a nominal fee to cover kind of the costs associated with processing an application. You will probably be required to pay deposits before you move in, but you shouldn't be required to pay a deposit at the point that you are just applying for an apartment. If you haven't been approved to live in the apartment yet, you shouldn't be required to pay a security deposit or a pet deposit or anything like that. When you're going in to pay deposits because you're getting ready to move in, make sure that you are familiar with what is refundable or possibly refundable and what is considered non-refundable. A security deposit should always be potentially refundable after you move out, and we'll talk about that more at the end. But other things may be non-refundable, like a lot of pet deposits are usually non-refundable. Just make sure that you're clear and the paperwork is clear about what is refundable and what is not. Landlords can do background checks. They will probably run a credit check. I know we're having a lot of issues recently with landlords who are looking at eviction cases that have been filed, and maybe some other debts to prior landlords or utility companies. If you're concerned about that, it might be a good idea to pull your credit before you start applying, so what's on there and make sure that it's all accurate. If there's a discrepancy, if there's something that you don't agree with, you can dispute it through the credit bureaus, but you can also contact legal aid and we can try to talk with you about your rights regarding your credit and making sure everything on there is accurate. Make sure that you inspect the property that you're going to be renting before you move in. If they want to show you a property that is similar but not the property you're going to be renting, that's a red flag. You want to make sure that you see the property you're going to be renting, whether it's an apartment in an apartment building or a house, whatever it is. You want to see what you're going to be renting before you move in. And as you're going through, write down any issues that you notice. And do make sure you do things like, run the water, other things like that. If there are some minor issues, if you notice like there's a little stain on the carpet, but you don't really care about that because you're going to put your bookcase there or whatever, just make sure you note it. So at the very least, when you move out, you don't get blamed for that stain being there. If there are major issues, if it looks like the heating and air conditioning isn't working, if there's flooring is loose or things seem to be rotting, if you're seeing mold on the walls or indications that there might be an issue like that, and obviously you may not see them when you're doing an inspection, but you may. If there are serious issues, even if the landlord is promising you that they're going to make repairs, and yes, they are responsible for making repairs, but if there are serious issues, I strongly recommend, if you can, walk away, because 9 times out of 10, those repairs aren't going to be made, and they're certainly not going to be made in the week before you move into the property. So please, consider if you have other options, not moving into that property. It doesn't mean you're out of luck, but it can be an issue. As you're signing the lease, make sure you review it. You can. I know a lot of times people will feel like they're being rushed through reading stuff, but you can take it, say, just, I need a minute just to read this. Go ahead and read it and make sure you get a copy of it. If need be, if they say the copier's not working, try to see if your phone has a camera, if you can take pictures so that you will have something to refer back to if you need to later on in terms of what the lease says. And make sure you do ask questions as you're going. If you're concerned about something, if something's not clear, go ahead and ask about that. It's better to know what you're getting into, or at least try to anticipate, something looks like it might be a problem, but let's see if we can figure this out now, before you actually sign everything and move in. During the tenancy, make sure that you're following the terms of the lease. As I said at the beginning, make sure the rent is being paid. Know your guests. You could be responsible for their conduct, even if you're not aware that they're doing something, even if you're not aware that they're still on the property. So you want to make sure, if someone comes over, if you invite them onto the property, that you know them well enough to know that you can trust them. Make sure that if you've got pets or other animals, that's included in the lease, that it's written in either as a special stipulation or something like that. So it's clear that that it's known that those animals are there. As a side note, service animals and support animals are not the same as pets. And so there are additional protections. If you have those, you may need to provide some documentation, but there are additional protections, including that you shouldn't be charged any kind of pet deposit. But if you've got something like that going on, reach out to us so we can talk further with you about it. The landlord is just as bound to the lease as the tenant. So the landlord cannot come in and just say, hey, I've decided I need to raise the rent, even though you're in the middle of a lease. If the lease doesn't allow them to do that, they can't do that. Landlord also can't say, oh, I've decided to renovate this property, so I'm going to need to have you move out. If you're in the middle of a lease, you have the right to use and enjoy that property. They can't just say, oh, you got to move out now. Now, if the lease does have an early termination provision, they may be able to ask you to leave earlier, but they do have to follow the lease provision and the requirements of the lease to do that. So if there's ever a question, go back and check the lease. That's going to have a lot of the answers are going to be in there about what you can do and what the landlord can do. All right. The tenant has the right to use and possess the property. So the landlord is responsible for maintaining and repairing the property. And so they do have the right to sort of come onto the property to make those repairs, but they should do that in cooperation with the tenant. The landlord does not have the right to just come on the property anytime that they want to. They have given that right to the tenant. So the tenant, certainly should be involved anytime the landlord is going to be coming onto the property, and it should be for a reason like making repairs, not, this is my house and I want to see what's happening in it, because the tenant has exclusive right to use and possess the property. And the landlord can only evict the tenant if they go through the entire court process. They cannot change the locks. They cannot put the tenant out. They cannot disconnect utilities. They have to go through a court process to evict the tenant. As I was saying before, early termination of the lease is sometimes a possibility. If there's a provision in the lease that allows it, then either party can terminate the lease based on the requirements of the lease. If there's nothing in the lease that allows the early termination of the lease, then there are two laws that might allow that to happen. The first is a federal law that basically applies to active duty service members. If they're being deployed, if they're being moved, then they have the right to do an early termination of the lease under those circumstances. A tenant under Georgia law can terminate the lease early if they are fleeing domestic violence. So they have to provide the landlord with a written 30-day notice and provide a copy of either a civil protective order or a criminal family violence order, basically saying, that this is domestic violence and that this person needs to not come near them, but they want to flee the property so that the person can't find them. The tenant would be responsible for rent during that 30-day period, but they can terminate the lease and leave under those circumstances. Under Georgia law, the obligation to pay rent is separate from the obligation to make repairs. So the tenant has the obligation to pay the rent, and generally they cannot withhold the rent even if the landlord has failed to make repairs. If the tenant does withhold the rent, usually what ends up happening is an eviction case is filed. And as I said, that can provide all kinds of complications in terms of credit, in terms of just that's an expedited court process as well. So it can be really hard to kind of build your case, even if you raise failure to make repairs in the eviction case. So please don't withhold your rent. But if you do, please make sure that you save the money. You may need it later on. either to be able to move, or if you're able to get something resolved, you may still have to pay the landlord the rent in order to remain in the property as repairs are being made. But don't withhold rent. Landlords are required to maintain and repair the property, even if the tenant does not pay the rent. Now, generally, if a tenant breaks something, then the tenant does need to repair that. But otherwise, the landlord cannot transfer this duty to maintain and repair the property to the tenant. The landlord has to maintain the property. The tenant, however, can waive the right to damages by continuing to live in the property, signing a new lease, or just staying in the property after the lease term. Basically, the law says if you know there's a problem and you stay in the property anyway, yes, the landlord still has to make those repairs, but the tenant may not sort of seek compensation for having to deal with the issues or for damages to their property because they stayed in the house, even though they knew there was this issue. So if you are living in a property and you notice that something needs to be repaired, make sure that you give notice to the landlord. Certainly it's okay to call them and tell them, but please follow up with something in writing. Like I said, like an email or a text message is fine. Just make sure that there's something in writing so you have proof that you put the landlord on notice that there was an issue. The tenant is the one who's living in the property, so the tenant is going to have sort of superior knowledge of what's happening in the property. So you want to make sure that it's clear that the landlord knew what was going on. And then, like I said, hopefully the landlord and the tenant work together to allow access for repairs. The landlord does need to take responsibility to have maintenance people come out, or a professional plumber or whoever come out. The landlord should tell the tenant when that's going to happen, and make sure that the tenant is able to be there to allow the person in to make repairs. You don't, as a tenant, have to allow someone into the property if you're not going to be there. And you don't obviously need to, if it's a surprise, you should still kind of try to work with them. But if you really can't have them in there at that point in time, maybe ask them to come back at a more convenient time for you. If repairs are not made, Georgia law does allow tenants to do a repair and deduct. This does require a lot of notice before you can deduct. So first you have to make sure that you have given just kind of the general notice, dear landlord, this faucet is leaking, please come fix it. If they don't, you can send a follow-up notice saying, hey, dear landlord, I let you know that this faucet is leaking, it needs to be repaired. It hasn't been repaired. If you don't repair it in the next 2 weeks, I'm going to go ahead and pay for the repairs myself and deduct the amount from my rent. Landlord still doesn't repair it. You have a plumber come out, make the repairs, get the receipt from the plumber, send a copy to the landlord. So you've got your original, they've got a copy, and say, dear landlord, gave you notice, told you I was going to repair and deduct. This is how much the repairs cost. I'm going to deduct it from my next month's rent. Then you should be covered if there's an issue, but you do need to make sure you follow all of those steps. If it's a big repair, if it's something like replacing the water heater, replacing the heating, ventilation, air conditioning unit, something that's going to cost a lot of money, that's going to be more than 1 month's worth of rent, that is not really something that you should be doing for repair and deduct. It's too much of a big repair. Also, those are fixtures, so they're going to stay with the property after you move out. And so you've basically paid to improve the property. So if you have an issue like that, that's more something for housing code enforcement, contacting them in your local jurisdiction, having them come out, do an inspection. Maybe they send a citation to the landlord, maybe they just put them on notice that they have to make this repair. But generally speaking, that tends to be an incentive for people to make repairs when housing code enforcement gets involved. And of course, you can also, if you've had damages, if there's mold in the house and it's damaged all of your clothing and furniture and things like that, or impacted your health, there may be a way to file a lawsuit for the damages that you've suffered because of those repair issues that were not properly addressed. Okay, before we get into evictions, I want to allow folks an opportunity to ask questions. So Samantha, if you want to.
Yes, I'm going to actually have to scroll up a little bit.
Okay.
I'm going to start from the top and work my way down. All right. So the first question we have, from Ms. Tina T, can the landlord change the rent in the middle of an annual lease when the lease doesn't mention how to handle increases in rent?
If you have a lease and it has a set amount of rent, and it doesn't include any kind of provision for raising the rent in the middle of the lease, then no, then the rent is set for the term of the lease. Now, the landlord could say to renew the lease, the new rent amount is going to be X, when the lease expires, and they can raise it at that point. And there's no rent control in Georgia, so they can pretty much raise it to any amount that they like. But in the middle of a lease, no, not unless there's something in the lease that allows them to do that.
So our next question is from Anissa Gray. Are tax credit properties allowed to raise the rent excessively due to the market rate increases?
They shouldn't raise it excessively, but unfortunately, yes. There's a rent formula for tax credit properties, and it would be impacted by the area median income and by rents in the area. So yes, unfortunately, those have gone up quite a bit.
Okay. This message is from Taz Tard. Can a landlord charge you holdover rent twice the monthly rent without going to court?
I'm sorry, can you repeat that?
Can a landlord charge you holdover rent that is 2 times the monthly rent without going to court?
So that it may depend somewhat on the circumstances. Generally, landlords can charge, late fees and whatnot. And they may have some way to accelerate, all the rent that would be due under the lease if there's a breach. But most likely they would have to go to court in order to evict the tenant. That is a very strict requirement. There's no getting around that. And a court may determine that is a penalty, which is not allowed. So generally, I don't think that would be something that a landlord could do, but there may be some circumstances where it would be allowed depending on the terms of the lease agreement and some other circumstances.
Okay. We have a question from Cora Jean Farron. If you are robbed, can you leave the property early?
Unfortunately, there isn't anything in the law that specifically allows that. I would hope, though, that a landlord would be empathetic and understand that you wouldn't want to live there anymore. I don't do any premises liability, so I'm not sure if there's something under those laws that would allow it, but I think generally speaking, there isn't anything in the landlord tenant law that specifically says under those circumstances you would be allowed to leave. You could certainly ask, and I would hope that the landlord would be understanding and allow it.
Another question we have from the same person: if you change the locks for lost key, is the landlord responsible to give you a refund?
No. if you lose your keys, or if somebody who works for the landlord loses the keys. If you
Uh,
lose your keys, then you would, that would be on you. I think if the landlord, like if the maintenance person's keys were stolen or something like that, the landlord should change the locks. So you could maybe do a repair and deduct in that situation, but
okay. Another question from Tina T. Repair issues that are not addressed and the landlord tells you to take it up with your rental insurance when it's their fault. Can they do that and not pay on themselves?
okay, so I think my understanding is like if there are damages to your property because of a failure to repair, the landlord is still liable even if you have renter's insurance. You should file a claim with your renter's insurance because that might be helpful, but the landlord would still have responsibility and could be responsible for damages even if you have renter's insurance.
While I'm asking this question, Margaret, can you pull up, someone asked if you could pull up the rights and responsibilities slide. And
Which
then,
one?
oh, well, yeah, that's a great question. Leroy Scott, can you verify which one? And the next question, what if the utilities, water specific, are included in the rent and the landlord is saying that they are going to increase the water amount? Can they increase the water amount in the middle of the lease?
So a couple of things with utilities. Generally speaking, in the middle of a lease, the rent is set. And if the rent includes utilities, then unless the lease allows for an increase, that amount is set. If it's a situation though where like the water is billed separately, so you pay rent and water together, but the water is billed separately, the water amount may increase if the bill for the landlord does increase. But that again would go back to what does the lease say about how the water bill is calculated and what the landlord can do in terms of passing that on to the tenant. So, but if it's a set amount, if your $600 a month or whatever it is includes water, and the lease doesn't allow for an increase in that set rent amount, then the landlord can't increase the rent during the term, even if he's claiming that it's partly it's the water bill portion. But if the water is billed separately, then that it's possible that could go up depending on what the lease says.
So we have clarification on the slide for rights and responsibility. The last slide shared on the screen, I guess the last.
This one?
I believe so. And we have a hand raised, Leslie.
Mhm.
Go ahead and unmute yourself.
Yes, it was more of a comment. As you know, a young mother of 3 children, being out on my own at 16, I learned the hard way how to navigate renting my own space and then how to go about it and my rights, not just how to be on time and be courteous to somebody else's property, but also just knowing my rights and knowing all those things. So it was a trial and error, especially at a young age. So I want to thank NPU University for hosting this. I want to thank you, Margaret, for actually, you know, instructing us what our rights are and how to go about things properly and legally. Because we need it. A lot of times we're not taught this, you know, and we pick up as we go and we forget that other people are learning as they go too behind us. So
Yeah.
this is very, very much needed, especially now, like slowly after COVID, because we're still kind of in COVID, you know.
Yeah. Thank you, Leslie, and I hope everything has worked out for you. You know, as you said, it's tough. It's a lot of times it's counterintuitive for people who, you know, who aren't familiar with this. So thank you.
Thank you, Leslie. We also have a hand raised by Carolyn Randall. Go ahead and unmute yourself.
Hi, I wanted to get clarity about one of the renters' rights agreements, the rights and responsibilities slide. There was one you stated that if there was a lease agreement and then the lease had expired. So I guess in essence, my mother signed a lease back in 2011, I think it was. But once they signed it, their very first day, there was never a yearly lease signed. But they've now decided to sell the property.
Okay.
And since they've decided to sell the property, I was just trying to get clarity as to what did you said? Did you say that if they send a notification giving 60 days, is that only the 60 days that you said that you have, or that's the only right that they have? Because she's not like she's always paid, never miss a payment or like that. But then now they're saying they're going to sell the property, and we're just trying to get clarity as to, you know, what other recourse that she have.
Yeah, unfortunately, and this is a very common scenario, especially these days with the housing market being what it is. A lot of people are selling properties even though they've had long-term tenants. And unfortunately, that is all that they're really required to do, is give her the 60-day notice.
Okay.
If she stays there past the 60 days, they would have to go through a court process to evict her. They can't just come and put her out on the 61st day. But unfortunately, the only thing that they are required to do in advance is give her that 60-day notice.
Okay. Now, one other question is, does in the process of her within the 60 days, can they have people to start coming into the house to view the house or look at the house, like right in, you know, right while she's still there, or like she needs to make arrangements for them to, you know, to accommodate them, or can she ask or require that they wait till she's out in that time frame?
She can certainly ask, especially if she's got you know, stuff going on, like, you know, she's got health issues and she's concerned about COVID or things like that. Generally speaking, they can start showing the house, but they should be accommodating to her because she does still have the right to use and enjoy the property. So they, you know, they should work with her to find to come at reasonable hours, or you know, come when she can be there to make sure that, you know, she's watching the property. Or she can just say, listen, you know, given these circumstances, my things are in this house and I'm going to be moving, so it's going to be messy. So just if you can wait until I vacated, that would be best.
All right. Thank you so much.
We have another question in the chat. Can everyone receive help and or representation from legal aid, Atlanta Legal Aid?
So we do have income eligibility requirements that we will go over with anyone who calls us. Will be contacted by an intake specialist who will go through those eligibility requirements. And we handle civil legal services. So there are some things that we cannot assist with, like traffic tickets, you know, criminal matters, things like that. But for the most part, yes, if you're calling about a civil legal matter and you are income eligible, we will be happy to talk to you and see if we can represent you further. If we can't, if you're over our income limits, we will try to refer you to other organizations that may be able to assist you.
Free Harris, you can go ahead and lower your hand and unmute your mic. I can lower your hand.
Hi, my question is in regards to the last person that spoke. The story is similar to mine. The landlord was selling the house. They gave a 60-day notice, and I left before the 60 days, but then I got a notice that I was evicted from the person who bought the house.
Okay.
Are you about to get into that?
I'm about to get into the eviction process, but I will remind you here, so this is being recorded. So before we get into any further specifics about what happened with you, there will be our contact information will be shared. So if you want to call us next week, and maybe we can kind of try to figure out what might have happened, because if you vacated, then there shouldn't be any kind of an eviction or anything like that.
Okay, thank you.
Mhm.
I'm not seeing any more hands
Okay.
raised right now, so we can actually go on into the evictions
Okay.
part.
Okay. And of course, if people think of questions later on, we'll have questions again at the end. So, and if you have questions about stuff that came before, happy to talk about it there too. Just wanted to take that breath before we get into evictions, because usually there's a lot of questions about evictions. So this is a court process. It is required by Georgia law. Landlords have to do it. And they have to complete the entire process in order to lawfully evict a tenant. If you are involved in an eviction, one's been filed against you, please consider the court to be another party in the case. Meaning, whatever conversations you and the landlord are having, make sure that you are still doing everything you need to do in order to protect your rights with the court. So file an answer, even if the landlord says, we'll work with you and we'll get this resolved. Keep the court informed. If you guys come to an agreement outside of court, make sure that it's in writing, it gets filed with the court. Just make sure that the court knows what's going on, so that you don't get surprised if something happens because you thought something was resolved and turns out maybe not. Also, and just keep in mind too, like the landlord is the person who is suing you. So yes, they may be willing to work with you, and yes, they may be cooperating with rent assistance and all of that, but they are still the person who is suing you. So they're not necessarily going to be having your best interests in mind with regard to a court process. So that's why you need to make sure that you're doing everything you can do to protect yourself with the court process. There are no more moratoriums in place. The federal moratoriums that were COVID related are done. Most courts are pretty much through all of the cases that were pending. There are still some courts that have a delay in some cases, but most cases now are back to kind of our pre-pandemic expedited process. So from start to finish take maybe around a month, which is fast. So just make sure that you're watching everything and keeping an eye out as you go through this process. So an eviction may be filed for any breach of the lease or the terms of the tenancy. The vast majority of cases are filed for non-payment of rent. The landlord must demand possession prior to filing the eviction. This is the only requirement in Georgia prior to filing the eviction. And it is as simple as the landlord telling the tenant to get out. They can put it in writing if they want to. They don't have to. It can just be get out. And if the tenant doesn't leave, they can go and file an eviction case, also known as a dispossessory. That's the word that's going to be on the court papers. I'm just going to call it an eviction. Same thing. If you live in subsidized housing, if you're in a tax credit unit, an income-based rent unit, if you have a voucher, there are additional requirements under federal law, but under Georgia law, the only thing that has to happen is a demand for possession. The eviction is filed in the county where the property is located. And as I said, it's an expedited process. This is the sort of initial filing for Fulton County. Each county's filing forms are going to be a little bit different, but they're fairly similar. And so I posted the one for Fulton County here, just so people can kind of see it. It's a couple of things that I want to make sure people kind of can see. At the very top, obviously, it says Magistrate Court of Fulton County. So if you get a notice from your landlord saying, I'm evicting you, that's important information to have. That's basically the demand for possession, but it's not the court papers. Obviously, the court paper is going to say magistrate court or state court of whatever county you're in at the top. The next bit is going to be, why they're evicting you, things like that. But the important part is sort of down towards the bottom where it says constable marshal entry of service. And it will say date of service and defendant to answer on or before. Those are very important dates. Whoever serves it is going to write in, date of service, June 23rd, 2022, defendant to answer on or before June 30th, 2022. And we'll talk about answers more in a minute, but that's the key date. And you need to be very, very aware of that date and make sure that an answer is filed by that date. Just above that, the paragraph that says summons, that's the information you need right there about where you need to go to file an answer. So that's going to tell you where the courthouse is, give you the address. In Fulton County, you can file an answer online if you want. There is a processing fee for the software company if you file an answer online. If you go in person to the courthouse, there's no fee to file an answer. But you can do either one. You just need to make sure it's done by the deadline. So please, if you get this form, make sure that you read through it and you know what your answer date is and you know kind of where you need to go and what you need to do to file the answer. In Georgia, you can be served personally. That's by either a marshal or a process server. That just basically means that they hand it to you. Notorious service is when they hand it to someone who lives in the property and is of suitable age. So basically a teenager or older. So if you expect maybe an eviction is going to be filed and you have kind of older kids, make sure that you talk to them and let them know if they get something to give it to you immediately. The most common way that people are served is by what's called tack and mail. And this is where they tack a copy to your door and then mail a copy to you. They are supposed to knock and try to actually do personal service before they do tack and mail. But usually people end up getting served by tack and mail. The mailed copy needs to be mailed the same day that the tacked copy was tacked. So if it's tack and mail service on the 23rd of June, but the envelope has a postmark for June 25th, then service was not proper because it wasn't mailed the same day that it was tacked. If you are served with an eviction and you think that service was not done properly, when you go file your answer, make sure you say that in your answer. Just, you don't have to write anything other than service was not proper, but you can get into, not the mailed copy was mailed on the wrong date, or the person that was handed the warrant is someone who doesn't live with me. You can put that in there if you want. If you're served by tack and mail and the mailed copy is sent on a different day, make sure you save the envelope so that you have proof that the mailing wasn't done properly. If you are served by tack and mail and you do not file an answer by the 7th day, the landlord will get a judgment that allows them to have possession of the property, but not a money judgment. So if you're in the process of moving out and you come back to the house to get the last of your stuff out and there's a eviction warrant on the door and you're leaving anyway, you don't necessarily have to file an answer. If you don't, then what will happen is the landlord will get possession, which is what they're getting anyway because you're moving out, and not a money judgment. Doesn't mean that there might not be a money issue to deal with later on, but it won't be a money judgment at that point, which means that they won't be able to garnish your wages or do anything else to try to collect any money that they might claim you owe. So this is the answer form in Fulton County. Again, most of the counties, at least in the Atlanta area, are going to have an answer form that's similar to this, but maybe not exactly the same. But this is what you'll find if you go down to the courthouse. You're served with an eviction warrant. You're within the 7 days to file an answer. You go down to the courthouse. You tell them that you're there to file an answer in an eviction case, and they will hand you this form. If you go online, you'll see an electronic version of this form. The top part there under dispossessory answer, just your defenses to the eviction. So if the landlord is claiming that you owe rent, you can check off, I do not owe any rent to my landlord. If you're disputing the amount that is owed, you can check off, that they terminated my lease without a valid reason, or you can write in, I don't owe what they claim I owe, or you can just check I don't owe any rent to my landlord, and then you can go in and kind of have the judge kind of look at your evidence versus their evidence and figure it out. You can also check off things like the landlord failed to repair the property, anything that would apply, go ahead and check it off in the defenses. Down below that is where you would put in your counterclaims. So failure to repair, you can check off both as a defense and a counterclaim if it applies in your case. And then you can let the court know, though, if there are other reasons that you think that the landlord might owe you money for something, like maybe they illegally locked you out prior to filing the eviction warrant and you had to stay at a hotel for the night, and so here's your hotel bill and you want to be reimbursed for that. All of that would go into a counterclaim, and then you would turn this in and to the clerk and file it. It used to be, you'll notice at the bottom it says notice of trial date. It used to be that the clerk would just schedule the case for a hearing, usually within a week or two from when the answer was filed. They are not doing that at this point in time. They may go back to it eventually, but they're not at this point. What they are doing, at least in Fulton County, is taking the answer, filing it, and then scheduling it for a hearing and mailing a copy of the hearing notice. So even if you file an answer online, you will get the notice of the hearing in the mail, not by email. So make sure that the address that they have for you is correct and complete. And if you're having issues with your mail, so you have mail go somewhere else, there's a form that you can fill out to ask that your mailing address be changed so that the hearing notice is sent to that address instead of one where you're maybe having trouble getting mail. And then make sure after you file the answer that you're checking the mail regularly, because we are now getting to a point where in Fulton County, a lot of cases are being scheduled for a hearing about 2 weeks or so after the answer is filed. And so that's a really fast turnaround, and you want to make sure that you get that notice so that you attend the hearing. So as I said before, the answer is due within 7 days of the date of service, and that will be written on the answer form. The person who is the named defendant is the one who needs to file the answer. If there's more than one named defendant, if it's, Billy and Susie and all others, Billy and Susie both need to file answers. They can file one answer together that they both sign, or they can file individual answers if they want, but they both need to file an answer. If the named defendant isn't available, if they've moved out of the house, or some other reason, it's not an option that person can file an answer, the person who is an occupant of the property can go ahead and file an answer and say, just check on the answer form. I'll kind of go back to that. The very top, it says, I am the check one defendant or occupant. in that situation, if the named defendant for some reason can't file the answer, the occupant should go down and file an answer. This is better to have the answer filed and have the protections of the court kind of continue to be in place, even if the named defendant isn't there. And like I said, they can raise defenses to the landlord's claims and raise counterclaims that you might have against the landlord. If no answer is filed, then a default judgment will automatically be entered against the tenant. As I said before, if it was tack and mail service, that will be for possession only. If there was personal service, that will be for possession and a money judgment. There's absolutely no way to appeal a default judgment. If there is some kind of a compelling reason why the answer wasn't filed on time, the tenant can go down and file a letter with the court explaining why the answer was filed late and explaining what their defenses and counterclaims might be, so the court can see this is what happened. And if the case is reopened, these are the defenses and the counterclaims. The court has discretion whether or not to reopen the case and schedule it for a hearing. So please make sure you file an answer within the 7 days. Like I said before, even if the landlord is saying, oh, don't worry about it, we had to file that, but we're working with you, all of that, still make sure you go down and file an answer so that you'll have the opportunity for a hearing and to sort of formally get things resolved. Because otherwise, once the default judgment is in place, the landlord is legally allowed to evict the tenant. And as I said, because you can't appeal, there's really very few to no options to stop that eviction. All right. You will get, like I said, a notice of the court hearing once it's been scheduled. That will be mailed to you. At this time in Fulton County, they are still doing hybrid hearings. Participate either on Zoom or in person. They are moving away from that. So make sure that you pay attention to the notice, because it may, by the time a case comes around in the next few months, it may be back to all in person. You need to make sure that you are on time for court. So once you're in court, you will have the option. In most counties will give you the option of going to mediation. In Fulton, they have a kind of a formal process. So they have mediators there. They'll send you into a room. If you're on Zoom, you'll be in a breakout room. Kind of get a chance to try to work out everything with the landlord. I usually recommend to people, if you're going to go into mediation, it's a good idea. Hopefully you can get something worked out, but try to ask the mediator after you kind of do your initial rounds. So the landlord will talk first, and then you'll have a chance to talk. Then maybe ask the mediator if you can meet separately. It's called a caucus, where you meet with the mediator and then the mediator goes and talks to the landlord. I think it just helps people to be able to breathe a little bit, kind of helps calm their nerves a little bit. They're not looking at the landlord. They can kind of talk through things a little more freely and figure stuff out without feeling as much pressure. So if you are going to go to mediation, it's an option. You don't have to do that, but I do usually suggest to people that that's a good idea, just so that they can have some time to really think and figure out if they want to sign this agreement. If you sign an agreement in mediation, it is binding. There's no way to go back and change it. So, I mean, if you and the landlord agree to, and you put it in writing, you can change it, but there's no way to go back to the court to change it. So make sure before you sign it that you can live with the terms of that agreement, and that everything that you've agreed to is in the agreement. So if the landlord has agreed to make repairs, but that's not written down, make sure before you sign it that gets written down in that agreement. If you don't work something out of mediation, or one or both parties don't want to go to mediation, you'll go back into the court. You'll have a hearing before the judge. Both sides will have a chance to talk. The landlord will go first because they're the ones that filed the case. The tenant will go next, but they'll have a chance to present on their counterclaims as well as their defenses. You can present, any documents you have to support your case. You can bring witnesses. You can't bring notarized statements or written statements in exchange of having a witness. You need to have the witness there. That's because the other side has the right to ask questions of that witness, and they can't do that if it's just a written statement. So even if it's a notarized statement, that's not sufficient. The witness needs to be there. After the hearing is over, the judge will make a decision. Usually they make the decision right there. Sometimes they'll say, I'm going to take this under advisement. So that just means they need to think about it a little. You'll get the judgment usually within the next couple of days. If the court decides against the tenant, then a writ of possession will issue within 7 days. If the tenant does not appear in court, there will be an automatic default judgment entered against them. And that will include both possession and a money judgment. And also when there's a default judgment, possession is immediate. So there's no 7-day waiting period before the landlord can get the writ of possession. They can immediately ask for one. So you do want to make sure that you are definitely at your hearing and that you're on time. Try to get there a little bit early so that it's clear you're there. If a case has to be continued for some reason, like if you go in for your court hearing and then they're gonna reset it for another 2 weeks for whatever reason, at that point, the landlord can ask that rent be paid into court while that case is still ongoing. Haven't seen that as much lately, but it is a possibility. So just be prepared for that. Some common defenses that people will raise in eviction cases. One is that there's no landlord-tenant relationship. Now, this is not a defense for a case where like there was a lease and it's expired or there never was a lease. There is a landlord-tenant relationship in that case. It's just not formal in a current written lease. But that is a defense that you can raise if it's, family members trying to evict each other from a family house, or roommates, sometimes will try to evict each other. There's not a landlord-tenant relationship there, so that's a defense to the eviction case. If service wasn't proper, you can write that down. They didn't demand possession, or if it's federal housing, subsidized housing, the proper notice wasn't given. Obviously, no breach of the lease. My landlord did not have a valid reason to terminate my lease agreement. Is basically just saying I didn't do anything wrong. There's no reason for them to be evicting me. I'm disputing this. If you tried to pay rent and the landlord wouldn't take it, that's definitely a defense to non-payment of rent. But like I said before, make sure that you've saved that money order or check or whatever it was so that you have proof that you tried to make that payment on time. But definitely if you tried to make that payment and they wouldn't take it, or if you've been making partial payments all along and they've been accepting that, or you may have a lease that says, rent is due by the 5th of the month, but during the entire term of that lease, or most of it, you've sort of made 2 payments per month for the rent. You made a partial payment at the beginning of the month and a partial payment mid-month, or you've just kind of been making irregular payments throughout your tenancy. And then suddenly the landlord says, no, you need to pay this all right now without giving you any kind of notice that they're changing it back to the original terms, or that they're changing the terms, period. Then those are defenses. Now, the landlord may be entitled to some kind of a money judgment, especially if you've been making partial payments all along. You may still owe the rest of the money. But if they've been taking the partial payments and they're continuing to take partial payments, then they shouldn't be allowed to have possession of the property, even if they get a money judgment against you. But you need to make sure you raise that to the court and you bring proof of your payments, especially recent payments. But if we're talking about, you have a history of making kind of irregular payments, you want to bring that history to court to kind of show the judge, like, this is how we've been doing this all along. They can't just come in and say, all of a sudden, we're not going to do this anymore. Also, if something happens and then they don't try to evict you for a while, you can argue that they have waived the right to terminate the lease for that reason. The case that where this defense came up was a case where, like, there was an arrest in someone's apartment, and then 7 months later, the landlord decided to evict the tenant based on that arrest. That's not allowed. Now, it was like a guest that was arrested, but still, it was, the court basically found, like, you knew about this. Clearly, it's not a reason to terminate this person's lease if they were allowed to continue living there for 7 months. Bankruptcy can be tricky. If you filed a bankruptcy, so like if I file a bankruptcy today and I haven't paid rent in 6 months and I include the landlord as a creditor, I can file the notice of bankruptcy in the eviction case. And that should, because there's an automatic stay with the bankruptcy, that should stop the eviction. And that will take care of the back rent. But where it gets tricky is next month is July. July rent is not included in the bankruptcy that I filed today. And I need to pay July rent, or the landlord can go back to the bankruptcy court and say, please lift this stay so that we can move forward with the eviction case. I think what should happen then is that a new case should be filed for non-payment of July rent. But oftentimes what happens is they just reopen the old case and move forward with a non-payment. So bankruptcy can be a way to sort of stop an eviction, but you do need to be careful and really talk with your bankruptcy attorney, and maybe even contact legal aid to make sure that the protection continues past the current month where you filed. Common counterclaims. Obviously, like we've been talking about, the landlord failed to maintain and repair the property. You could have damages like what we call actual damages. So like I had to go stay in a hotel for a week because we didn't have heat and it was February, or we didn't have air conditioning and it's 100 degrees in June. The hotel bill, then you want to be reimbursed. There's your actual damages. Sometimes it can be something where it's not really that easily quantifiable, but you're still saying, listen, I had to live in a house that didn't have air conditioning when it was 100 degrees in June. I would like some kind of compensation for that. Or in a lot of cases, what we'll ask for is what's called diminution in value. So I have a 3-bedroom apartment, but one of the bedrooms, there's mold growing up the walls. We can't use that room. So what I really have is a 2-bedroom apartment, in addition to maybe some property that was damaged, or clothing that was in there, or whatever it is. But what you're going to go in and ask for is that the rent be decreased from what you were paying for a 3-bedroom to a 2-bedroom. What would be a 2-bedroom apartment cost for that area? The landlord did something to breach the lease agreement other than maintain, prepare, and repair the property. An improper eviction, so they locked you out, they disconnected the utilities. You would ask for damages. It's part of a counterclaim based on that. Landlord kept coming onto the property every day and basically interfering with your ability to use and enjoy the property. You come home from work and landlord's just standing in the living room because he let himself in. Under the law, that's called a trespass. And you could raise that as a counterclaim. And then in some cases, maybe there was a violation of a fair housing law. You do have to have a specific legally covered reason that the landlord maybe was discriminating against you, but something like my landlord wouldn't allow my service dog in the property, that's a violation of the fair housing law, something like that. Okay. If you've gone through the magistrate court process and you disagree with the judge's decision, you can appeal that decision. You can appeal it from the magistrate court to the state court or the superior court. In most cases, it doesn't really, most cases go to state court, but it really doesn't matter which one you go to. In some cases, we'll appeal to superior court because there are some remedies that we might be able to get there that you couldn't get in state court, but in most cases, either one is fine. That appeal must be filed within 7 days from the date that the judgment is entered. And there will be appeal costs that the court will ask you to pay. The appeal will be dismissed if the appeal costs are not paid timely or if they're not waived. So you can ask the court to waive those appeal costs. You'll probably have to fill out what's called a pauper's affidavit form that the court has, and then go and talk to the judge. But if the judge signs off on it, then you can get those appeal costs waived. Once the appeal costs are made, the case will be docketed in the new court, and then it's what's called a de novo appeal. Basically means a do-over. So all of the pleadings go up, but a judge hears the case as if it's not been heard before. So all of the evidence can be heard again. There's a whole new trial. All of that happens again. Georgia law does require that tenants pay rent into court while the case is on appeal in order to remain in possession of the property while the case is on appeal. So if rent is not paid, the appeal should continue, but the tenant could be evicted. And in most cases, I think that kind of sort of moots out the reason to have an appeal, but you might have a legal claim that you want to be heard even if you're moving out or not going to be staying there any longer. Under Georgia law, any amount of past due rent that the court finds is owed in the magistrate court is due by the appeal deadline. So if you owe 6 months of rent or 8 months of rent and the court finds that and you want to appeal the decision, you can file the appeal, but you will have to pay all of that back rent into court by 7 days from the date that the judgment is entered, which is usually the date of the hearing. And then ongoing rent has to be paid by the 5th day of each month. So again, like I said, like if I have cut court today, I want to file the appeal. My appeal is due 7 days from today, the 30th. I would have to pay, let's say I haven't paid rent this year, so I would have to pay January through June rent into court by the 30th. And then on July 5th, I would have to pay July rent, August 5th, August rent, ongoing while the case is on appeal. If the payments are late or not paid, then the landlord is allowed to apply for a writ of possession and have me evicted, even if the case continues on appeal. The judgment from the magistrate court should have the information about rent being paid into court and the appeal and all of that. So make sure you get a copy of that. It usually won't be available when you're in court, but should be available the next day. So you can go back down to the court to get it, or you might be able to get it if it's a court that has documents available online. After the 7 days have passed, if no appeal's been filed, or if the rent hasn't been paid, or if there's a default judgment immediately, the landlord then has to complete the process by getting a writ of possession. So they have to go down, apply for the writ of possession. A judge will sign off on it. So somebody does review the case to make sure that the landlord is legally allowed to get the writ of possession. Once they have it, they coordinate with the marshals to come out to lawfully evict the tenant. The marshals are there to keep the peace. The landlord has to kind of hire someone to come in and actually remove property from the house. Usually the writ should be executed within 30 days of the day that the judge signs off on it, that it's issued. Because there is still a backlog of cases from COVID and all of the moratoriums, we're seeing cases where the evictions are taking longer than 30 days. But generally, there's really no way to know how long it might take. So while we are seeing cases that are taking more than 30 days, we are also seeing cases that are taking less than 30 days. Once the writ has issued, you should assume that an eviction will happen at any time, and you may not get notice that it's going to happen beforehand. So if you know a writ has issued, or you know it should have probably issued, make sure that you are doing everything you can to secure your possessions, especially important papers, birth certificates, passports, medical records, all of those things, medications, make sure those are secured. And then anything that is of value to you, make sure that you have all of that secured so that you don't lose it when the marshals come out, because you're not going to have really any time to try to secure that stuff once the marshals are there. Okay, just a couple more real quickly, and then we'll have another round of questions. Once you get to the end of a tenancy and you want to move, or the landlord doesn't want to renew, proper notice has to be given. So again, like I said, the default in Georgia is 60 days from the landlord, 30 days from the tenant, but a lease may say something different. Most leases that I see say either party has to give 60 days or either party has to give 30 days. So do go back and check your lease and see what kind of notice you need to give if you want to move out, or if you get a notice from the landlord, make sure that they have properly given you notice. Again, if you're moving out, make sure you put it in writing, keep a copy for yourself. An email is fine. Once you move out, as you're moving out, do a move out inspection. Try to do it with the landlord, but if they won't do it with you, make sure as you're leaving, you take a video, you take pictures, you have some kind of a record of what the property looked like when you left. And also keep your records from what it looked like when you moved in, so that you can compare them if you need to. And please make sure you return the keys. Give them to, put them in a Dropbox, mail them to the landlord, leave them in the house if you can lock up the house and leave them in there, but please make sure you return the keys. So that it is very clear that you returned possession of the property when you moved out. The landlord has 30 days from when you move out to either contact you and say, this is why I'm keeping the deposit, return the deposit, return part of the deposit, and explain why they kept the rest. And then there are some additional requirements if the landlord is a corporation or has 10 or more rental units, but all landlords have to follow this. If part of the deposit is returned and you disagree with the reasons for them keeping the other part of the deposit, you cannot cash the check. If you do cash the check under Georgia law, that's considered what's called a court in satisfaction. That's basically legally you have agreed with the landlord's decision by cashing the check. So if you do disagree with it and you want to challenge their decision to keep the rest of the deposit, you cannot cash that check. If that happens, please contact legal aid so we can talk through what you need to do and maybe try to assist you with it. If they keep part of the deposit or all of the deposit and you disagree with it, you can definitely challenge that. You can send a demand letter asking that they return it, and you can file something in small claims court if they don't. Landlords are allowed to keep deposits under certain circumstances. If you leave owing money, they can apply the deposit towards that rent that's owed. But mostly they're allowed to keep deposits if there is damage to the property beyond normal wear and tear. And that's one of those like legal terms that seems like it should be clear, but is not always. And it will depend in large part on how long you live there and what kind of damage there was. If you live in a house for 10 years, they're going to have to repaint the house. That's normal wear and tear. You're probably going to have to replace the carpet too. That's normal wear and tear. If you lived there for 6 months and it was new carpet when you moved in and the carpet is all torn up and it has stains on it, then you may be responsible for the carpet. But it all depends on kind of the totality of the circumstances. But in a lot of cases, deposits are not refunded when maybe they should be. And so if you think that you should get your deposit back, definitely reach out to talk to someone about it. But make sure that you keep those records that you got from the landlord as well. Keep the letter that they sent explaining why they were keeping it, what they are claiming you owe, all of that. And prior to that, as you're moving out, either give your landlord a forwarding address, or if you don't want to do that, make sure that your mail is forwarded so that you get the letter from the landlord, because they have to send this notice to your last known address. So if you don't give them a forwarding address, your last known address is the apartment you were renting from them. Okay. All right. Do we have questions?
We do have questions.
Okay.
There's some in the chat. And thank you, Kip, for sending me these, because scrolling up has not been my best. The first question we have, yes, the slides are available for this session. But the question from Taz Tard: if you go to court and the judge rules in your favor, denies the writ, does this go on your eviction record? Is it possible to have it removed?
Possible. Not easy, but possible. So there's a couple of ways that evictions will show up on someone's credit report. The first is the vast majority of court records are public. So an eviction will show up just in the public records section that an eviction was filed. But it should also show what happened with that eviction. So, there should be something that says judgment for tenant or something like that. But just the fact that a case was filed will show up. If it ends up in a money judgment against the tenant, that will also show up then as a debt owed to the landlord. Now, if you have an eviction and you want to try to get it sealed, they're not going to seal it, just because you're having a hard time. There has to be some other circumstances. But we've gotten some sealed for folks who, like, the eviction was filed after they moved out, so they never knew about it. The case was filed but then dismissed. If you had a case where you filed a counterclaim and the judge found in your favor, or the judge just found in your favor because they determined that the landlord didn't have grounds to evict you, you may be able to file a request for the court to have that sealed if you can show that it's kind of harming, just the fact that the eviction was filed is harming your ability to find new housing. It's not an easy process. It's not really even necessarily a straightforward process. So I would recommend maybe contacting legal aid so we can talk to you about it and see if that's something we could assist you with.
Okay, another question we had. Are courts still backlogged with evictions? Are hearings virtual or in person?
So most courts are through the backlogs. Fulton still has a backlog in some types of cases, but they in the majority of cases are through that backlog. I can't speak to other counties because I really only practice in Fulton, but my understanding from my colleagues is that they also are sort of have processed through those backlogs as well. In Fulton County right now, they are still doing hybrid court. So you can participate either on Zoom or in person. I am not sure. I think like Cobb and Gwinnett are all in person. I'm not sure about DeKalb or Clayton. I do know that Fulton is moving towards having everything be in person. But right now they are still doing the hybrid. When you get the court notice for Fulton, so right now when Fulton mails the court notice, it will have the Zoom login information if you choose to participate in Zoom. And it will tell you you can participate in person or on Zoom. My guess is once they move to having no more hybrid court, it's just going to say you have to appear in person. So when you get the notice of the hearing, pay close attention to what it's saying, probably right in that first paragraph about whether or not you need to be in person or on Zoom. But if it has a Zoom login, you should be able to do it on Zoom.
Okay. Let me see. Is there any type of law concerning someone being asked to vacate that's elderly?
No. I mean, there are some laws that do have extra protections for seniors, but there isn't anything in the landlord tenant law that says that just because someone is elderly, they can't be evicted.
Are there any rules or guidelines regarding how much can be deducted from security deposit for damages to property noted by landlord at the end of the tenancy during the move out inspection?
Okay, I'm not entirely clear on what they're asking, so I'm going to try to cover this in a couple of ways. Landlords may have kind of a damage amount chart that they'll try to apply. I think, so they'll go through and they'll be like, oh, this light bulb is this amount or whatever. If it's reasonable, I think a court would allow that. But really what should happen is I move out, 20 days later, my landlord sends a notice saying, this is what we've deducted from your security deposit. That should be based on their actual costs for repairing whatever damages were beyond normal wear and tear. So if they had to pay, $500 to paint a room because my kid wrote in markers all over it, and they couldn't get it off, that deduction should be based on that actual cost. So I hope that answers the question.
Okay. Can a landlord or tenant notice to vacate, non-renew, overrule what the law says? If the lease says either party gives the other 15 days notice to vacate, does that trump it?
Mm-hmm. Yes. So the default, the 60 days from the landlord, 30 days from the tenant, that's just there if there's no lease or the lease is silent as to what kind of notice has to be given. But if the parties have signed a lease agreement saying we'll give each other 10 days notice, then that's what controls in terms of what kind of notice has to be given. There are some lease provisions that would be considered basically illegal. So like if there was a lease provision where the landlord said the tenant has to maintain and repair the property, I'm not responsible for that. The law specifically says landlord can't do that. Then there's a few other things that are like things like the landlord has to go through the court process. If the lease says landlord can just come and change the locks and put the tenant out, that's illegal. It doesn't matter that the lease says that, the landlord still has to go through the court process. But as far as the notice provisions are concerned, Georgia law basically says, here's what our defaults are, but if you guys decide you want to do something different, that's fine.
Okay, the next question that this person asked is Tina T. What was the term used when you accept a lesser value for the security deposit that you don't agree with? Is it the law of acceptance?
It's so the legal term is accord and satisfaction.
We have a question from Latrice Macklin. Will the eviction fall off after 7 years?
That is a good question. I think so, but I am not 100% sure about that. I can try to find out. And then maybe we can put something up on the Facebook page. But I will write that down so I remember to ask.
Is there a such thing as having an eviction expunged?
There is, but like I was saying before to the other person, having it sealed, having it expunged, it's not, there's not really a clear process at this point for that. You would basically have to ask the court, and you would have to show them that there's a, you would have to really get into the reasons why this case was maybe unfair, and also it's what it's how it's impacting you. The reason court records are considered public is because there's sort of a general theory that like the public should know what's going on. So you would have to kind of say my right to privacy overrides that for these reasons in this case. So it's not something that can happen in probably a lot of cases, but it's something that is possible. And again, if you think that it might be something that you want to talk further about, please call Legal Aid so we can get into the specifics of your case.
Okay, so I'm not, oh wait, no, there's another question. Have you ever seen the court expunge any, I think she just answered that. So yeah, she just answered that.
Okay.
All right, so if I'm not seeing any questions in the chat and I don't see any raised hands, I want to thank you, Margaret, so much for actually participating with us in this housing security series. I love what you all do at Atlanta Legal Aid, and I really just really do appreciate the work that you're doing as far as providing these resources for people when they may not know. Everyone.
And thank you, Samantha, for inviting me to do this, and thank you just for organizing these. This is really great. It's always good when people can get the information that they need. So thank you so much for doing all of this.
No, absolutely. So everyone, while I have you here for a minute or so, I would like to let you know about our upcoming courses, which you can see is being shared on your screen right now. So in the next coming month, we have our CP 1005, which is Civic Responsibility and Engagement for Young Adults. This is actually a week-long class for rising high school juniors and seniors that are part of Atlanta Public Schools and are interested in civic engagement and learning the legislative process. So if you have any of those in that age range in your house, home, or you know of, please forward them that information at npuatlanta.org. Another course that we'll be offering in partnership with Invest Atlanta is CD1004.004, Understanding Public Financing. That's TADs, bonds, MCTHSs, LAHTCs, etc. I do not have the definition of those acronyms in front of me, but as part of public financing, and Invest Atlanta is hosting this course with us. That class is Thursday, July 14th, 2022, 6 p.m. to 8 p.m. Another course we have next month is for our seniors course. It was actually postponed from June. It's our 6P1003 civic participation for seniors. And it's actually going to be an in-person hybrid panel at City Hall in the atrium. We hope to see some of our lively seasoned saints come out on Tuesday, July 26th, and talk and speak to the panel as to how they are active in their communities, as well as finding out how they can stay active in their communities. And then our final course for July is CP1006 Atlanta Community Engagement Playbook. This is actually going to be an in-person course. It is held on a Saturday, July 30th, 2022 from 9 a.m. to 4 p.m. It is only 25 slots. So when that application is available on June 30th, we just push and motivate that you all sign up for that course. If you have any more questions in regards to NPU University, please visit www.npuatlanta.org, and you can also email, follow us on social media at NPU Atlanta. That's at Facebook, Twitter, and Instagram, and then on Nextdoor, City of Atlanta Neighborhood Planning Units. And if we don't have any more questions, I bid you all adieu and a wonderful Thursday evening.
Good night, everybody. Thank you so much for being here.
Oh, also, you all will receive an evaluation email tonight, right immediately after this course, that will have the contact information as well for Atlanta Legal Aid. So look out for that email. It will be coming to you all in the next 5 minutes or so.
Thank you.
Good night, everybody.
Good night.
Well done, concise and informative.
Good night.
Thank you.